number 83, Town of Delaware versus Leifer.
Good afternoon.
Good afternoon, Council. Do you care to reserve some rebuttal time, sir?
If it's acceptable to the court, I'll reserve 2 minutes, please.
Of course.
Thank you.
You're welcome.
I believe that the statute or the zoning ordinance that we've challenged herein, its biggest deficit under the Constitution is that it's not narrowly tailored to address the significant governmental interest identified by the town of Delaware, which was to prevent excessive noise and specifically amplified music from dusk to dawn.
Where do you get that that is the limit of what the town intended to do here? I don't see that.
That brings me back.
What the town says is that it is trying to protect and preserve the character of this rural district. They don't say that it is limited to excessive noise or amplified music or anything like that. Where is that coming from?
First of all, as the court may be aware, we were deprived of the opportunity to depose the town supervisor and the code enforcement officer because I had consented to Mr. Klein's request for an adjournment of the deposition.
Well, let's just talk about what the
So I'm limited to
says.
his paperwork. I didn't get to ask those questions. Mr. Klein's own paperwork, if I recall properly, page 82 of the record.
But Counselor, the record is what it is before us. We're limited to that. For
So
however it
page
got to be
82
that
of
way.
the record is Mr. Klein's own affidavit when he moved for summary judgment, and he, as the town attorney, identifies the purpose of this statute as preventing amplified music from dusk to dawn.
That he limits it to that.
It's in
That
his...
You're telling, okay,
if
well,
I
I'll
re-
go back and I'll look at
I'm
that.
pretty sure it's his paragraph 16 of his affidavit.
What about the other, well, we can read that, but.
So assuming that's...
So you're assuming that that's all that the town intended to
I'm limited
accomplish.
to that by his own filing of the motion for summary judgment prior to my having my discovery.
Okay.
So that's what limited the record, and that's why it is what it is in the record.
Let me ask you a question about the town zoning code, and I'll ask Mr. Klein as well. But the way I read it, on Mr. Leifer's property, he's allowed to run a campground. That's a permitted use, a special use. It's got a little asterisk, so he has to have at least 4 acres to be able to do that, and he's got 40, something like that.
That's 68.
So that he could invite people to camp, they could set up tents, and there's not a limit I saw in the town code as to the number. Is that right so
That's
far?
my understanding.
Okay.
So, and while they're there, though, they're not allowed to
So could
sing
he,
or
so let
play
me ask
music.
this, could he set up an amusement park? on
Could
the
he?
land? Yeah, could he? Could he
Well,
set up an amusement park? Could he put up rides?
it's not prohibited by
How,
this particular challenged ordinance.
I see. How about building a hockey rink? Could you build a recreational facility on there?
It's not prohibited by this particular section of the
I thought there were
zoning
specific, I thought it was a specific use that was allowed.
Is it? I don't
I'm
recall
counting on you to
all
answer
the
that
allowed
question.
uses.
Slow down. I'm counting on you to answer that question.
Yes,
Is it an allowable use in an RU district?
I would have to search the
I see.
statute. I don't know that
Find
offhand.
it at page 142 of the record.
Right, and it is in there, I believe.
It isn't, the statute is in the
Yeah.
record, yeah.
Yes.
So and I imagine that if a hockey rink was allowed to have been erected in this,
My question is you have two parts of your argument. One that it's vague, the statute, and one part that it's overbroad. So the question is, can a distinction be drawn between theatrical/entertainment and these other activities that are specifically allowed, which seem to involve a large number of people and a public use of the land. Okay, it's all right. If you're not comfortable answering, don't worry.
No, I'm just not sure I understand the question.
It's all right.
As it relates to our issue here, but to the extent that gatherings are allowed for other purposes, no music would be allowed to have been played. You couldn't sing the national anthem at a hockey event under this. It would convert your hockey rink into a theater because
Since we're
you were
on the
playing
sports
music.
metaphor, my question to you is a softball. I wanted you to tell me, yes, Judge, yes, those things would be allowed, but those other things wouldn't. That's
Okay.
why I went that way.
Well,
All right.
yes.
Oh, there you
I
go.
do
All right.
agree.
Good, good.
I certainly agree. In fact, what I
They
think
require a
of.
special use permit, however.
The judge is right.
Okay,
They would.
well, what about a political rally?
Did the petitioner here apply for a special use permit for this event?
No, I believe he had originally applied for a variance as opposed to a special use permit. And I did not represent him in the course of that proceeding. I came in after this proceeding had already commenced to get the injunction that the town got.
Am I incorrect in understanding that under this framework here, that unless a use is specifically permitted, it is prohibited?
Yes.
In a particular
That is
district?
the way the zoning statute is created. So what I submit is that, for instance, the same gathering of people could have involved a political rally and could have generated as much noise, using amplified speaking. But, that would have been a permitted use, but the minute that group of people decided perhaps to sing a song or the national anthem, that then became a misdemeanor under the statute.
As I understood it, the theater restriction, which is what they're basing this on, includes the word facility, right? And then
Yes.
defines what a facility is, right?
Well, it doesn't actually define facility. And that was one of the questions we had, I think, in
Okay,
our
you're-
case.
You're right, but facility has a meaning of an ordinary meaning, right?
Yes.
Okay.
So that's why I argued that it violated the vagueness, that it was void for vagueness, because who would ever think that just having music or a gathering in an open field is a facility of some kind?
That's not what this was. This had stages, it had bathrooms, and it had food, other things that arguably would be considered a facility.
And,
right?
but of a temporary nature, perhaps, yes. But he wasn't constructing a theater in the usual sense.
You're
like
putting up
what we-
tents. Were there not tents being put up?
There were tents. That's
They're
all.
putting up a stage, right?
There may have been a temporary stage put up.
There were
I
things that
believe.
were built to make possible the event as he envisioned it, correct?
Yes, I agree with that. But my belief is that the zoning law would apply, for instance, if he had decided to build an amphitheater or a drive-in movie theater. That's the type of outdoor facility for
But
the
why
presentation.
is that fundamentally different from putting up a temporary stage for the period of time you need it and putting up speakers and amplifiers? Why isn't that the same?
The difference is whether a person would normally believe that their behavior was prohibited by the law. That's the vagueness statute. And a zoning statute would seem to be a regulation of the uses of the property and the buildings, the types of buildings that can be employed, as opposed to a simple gathering of people at which there's free expression. And the primary purpose
So
of being
where did the Woodstock event fall, under your definition?
well, first of all, that's a mass gathering, which is not applicable here because this was under 5,000 people, so it didn't trigger the mass gathering statute. But that's
your
it's a
description.
similar kind of event. It was a temporary 3-day event that people came to experience, music, to be together and exchange ideas, and the experience of the music itself. So it's similar in that regard because it's a temporary kind of arrangement. He's not building something that would continue on beyond the 3-day event. It's not something like a drive-in movie theater that would be used regularly outdoors to show films. It was just a gathering. We've had conversations with Supreme Court and so on about the idea that this is also a religious gathering. And the part of our objection here is that the injunction did not say, "Thou shalt not have a theater." It says you cannot have this event, the entire event. So the part of it that was a Sabbath
I want to talk
observance.
to you about that injunction. Let's say we don't agree with your arguments about vagueness and whether it's narrowly tailored and all of that and overbroad. What's wrong with the specific language of this injunction that requires it to be altered or remitted to the Supreme Court to narrow?
The injunction, if the court upholds the injunction itself, should just say that Mr. Leifer is enjoined from engaging in music, films, plays, or dramatic performances because that's what the ordinance prohibits. The ordinance
Your
does-
problem is the language that says any other event of the same kind, nature, or description on the premises?
Yes, that part of it I object to, and I object to it applying beyond the playing of music.
All right.
So, for example, to overnight camping, which
Do we
is
have
in
to
the
send it
injunction.
back?
Right. It should not prohibit the overnight camping, because that's not part of what the definition of theater is.
We
It
have to
should
send it
not
back
apply
for that,
to,
or do we have jurisdiction to tailor that language?
I believe the court can modify the order. That's the subject of this appeal, is the injunction itself.
Thank you, counsel.
Thank you.
Counsel?
Good afternoon.
Could we start with the injunction,
Sure.
the scope of it?
Well, the scope of it is,
Doesn't it
it's,
seem a little hard to know what's prohibited, and doesn't it seem to prohibit some things that shouldn't be prohibited?
Your Honor, respectfully, no. And the reason is, it's the appellant who designed his project, his program. He developed what he wanted to do on the land use. We're bound in that regard to what he was doing.
Why
All
should
we've
the
inj-
injunction,
and
why should the
just-
injunction prohibit him from overnight camping?
It doesn't prohibit him from overnight camping. It prohibits him from having that type of an event. Everything is completely intertwined. The music, the camping, the camping issue by itself, he can't do the overnight camping without going to the planning board and getting a special use permit, which he didn't obtain. It would have to be designated as a campground. That's under the zoning law in that RU district. So in that sense, if he had done it without going to the planning board, which is what he did, it would still be appropriate to prohibit it because he didn't have the requisite permit.
I want to ask a follow-up on that. It seems, and correct me, that the town is relying on the theater use, right? This is theater use, it's not a permitted use, it's not a special use for this rural district. Assume the theater use did not apply here, that it didn't meet those terms. Would there be other restrictions that would prevent this festival from going forward?
Yes, because the zoning law, the analysis started with, we look at the zoning law. He's making this use out of his property.
Right.
So we look at the zoning law. Does it fit within the zoning law? So I analyzed first the RU district. I can't find anything in there that corresponds to the use he's making.
Right.
Then I look at the overall zoning law, and I find there are in 2 other zoning districts this use of theater. And it's not what you would contemplate to be theater in its traditional, it's not the building down the street. It's a much broader definition of what constitutes a theater, and what he was doing fit out of everything that's
Let's
defined in
assume
the zoning law.
it did not. Let's assume it did not fit within theater.
We would be here, we would have taken the exact same action.
Why? Based on what?
Because there is nothing in the zoning law that permits him to do what he was doing.
so a music festival, let's call it, right? That with these types of attributes, that doesn't fit within any use or permitted use or special use within his district.
Not the way he had presented.
So
no.
whether or not it fits within the theater use, it would still be prohibited in your view?
Correct.
So why do we need to talk about the theater use?
Just because to identify that this is the only potential use that would be allowed in the town, number one. Number two, that use is not available in that zoning district. And I think also when you look at the constitutional argument, it also shows that there are alternative means available for the type of activities that he's complaining are the First Amendment argument. Those First Amendment impingements, so to speak, we're not impinging it because the zoning law makes other avenues available to that particular use.
So there are other places where he could hold this event exactly as he envisions it?
I can't say that, Your Honor, because you have to look at the size and scope of what he was doing. This thing was morphing year after year after year, growing exponentially. It got up to 400, 500. I think the last version of it may have been 700 people on 65 acres in the middle of the woods with no permanent facilities, no parking facilities, no sanitary facilities other than what little things are brought in. No review, no approval.
Did you limit your objection to music or amplified music?
No, Your Honor. In fact, I think, and that's, I think, a misnomer, too, that's been perpetuated throughout this record, at least on the appellant's point of view. If you look very early on in the record, the first thing that happened was the town made an application for a preliminary injunction. That application for a preliminary injunction was resolved by stipulation between the parties, and if you look at, in the record, I believe it's page 97, in there you will, where that stipulation can be found, in there you will see that the town addressed and made sure that it addressed not just simply noise. We were concerned about sanitary situations, parking. This is about health, safety, and welfare. It's not just about the impact on the community from noise or whatever, traffic. Hundreds of people were being brought into this facility, so to speak, that wasn't really developed properly. Certainly there weren't adequate sanitary facilities provided for.
What if this was a family wedding of 1,000 people, and they needed a place to stay, and they needed to be fed, and so on and so forth? Would that be prohibited?
In 1,000 people in this context, I think that it would be very difficult to practically make that happen. Theoretically, I suppose it wouldn't be prohibited, because if you could do that in your backyard, what it wouldn't involve typically a family wedding, it wouldn't go on for 3 days, and the music wouldn't commence at sunset and run all the way through to
I don't know, in
dawn.
some cultures, the wedding goes on for 7 days.
Well, perhaps so, Your Honor, but that would be atypical for the experience of the town of Delaware, I can tell you that.
Understanding you correctly, that the alternatives that are available cannot provide for this event as he envisions it.
I can't say that, Your Honor, because I'd have to examine, in the two other districts, in one of the districts, it's...
Well, you argued to the appellate division that there were alternatives, so what, I'm asking.
Well, and the appellate division agreed that...
As he envisions it, where are these alternatives?
The alternative would be to find a piece of property in one of the zoning districts, and if it's and in the zoning district where it's a special use, bring a plan to the planning board and obtain a special use permit and site plan approval allowing that to be done, where you would have to show parking, you'd have to show what your sanitary situation is, you would have a site plan that would show exactly where the...
And what district now exists where he could go and seek out such property?
I'm sorry, ma'am?
What district would he do that in? You're saying he can't do it in the rural district?
No, you could do it in, I believe it's the Cal R1 and the Cal B1 district, and that's all identified on the record.
But you don't know if there is such a property available?
I can't say that, no, Your Honor.
And I already know that there's case law about the market doesn't necessarily have to facilitate it. I understand that argument.
But for the theater requirement in the code, could he have this event, let's say absent the stage, absent the music, on his own property if he'd gotten a special use permit?
With the camping and everything else?
With the camping, yeah, with the camping, with some kind of sanitary facilities that the town said are adequate, necessary to grant the permit, but if he's not having amplified music.
I believe theoretically, I believe he could if he applied for a special use permit as a campground.
On his own property.
On his own property, sure.
Could he have had amplified music at some intervals of time?
Potentially, sure. because that might well be something that could be an accessory activity associated with a properly permitted campground. But what would have happened in that instance is there would have been planning board review, and they would have taken into account, as they usually do, what's the impact of this, and I would be very surprised if this planning board in the town I represent, or any other planning board, would allow that extent of overnight music to continue on. That's what, they would strike a balance. What the applicant would reasonably require in order to have his event versus how you would mitigate the impacts of that on the community and the surrounding area.
So he could have the parts of this event that are sort of what he calls the religious practices? Is that
No,
correct?
I don't think there's anything in the zoning code that the zoning law is content neutral. There's nothing in there that...
So the point about the number of people, the sanitation, all of that doesn't matter if it's just that they're going to exercise religious practices?
I have to give you the lawyer's answer, Your Honor. It depends. You have to flesh out those facts a little more. If you're having it with the camping associated with it, and it's going on for days on end, then you have to look again at the zoning law and see how does this fit into the zoning law. The appellant makes great moment of trying to equate this...
So let me ask you this in the context of this case, all right? He decides to build a sukkah. All right, a temporary structure on that property and invite all these people to come dine in the sukkah, fulfilling the commandment. Now what?
Well, Your Honor, I mean, I get it.
Can they camp out overnight in tents? No music. They're just gonna,
It'd be an awful big sukkah to get 700 people into it. They probably
No, they go in at times, in intervals. And I'm not talking about 700 people. I think he has self-restricted it to 400.
Even 400, I mean, you'd be talking about building a structure that needed a building permit. And again, I'd have to analyze that in the context of the zoning law and see how that fit. Because it's much more expansive than what you would traditionally expect to see in a sukkah. It goes back to that same dichotomy that we've got here. I can't whistle in my backyard. I can't sing a song. I can't watch a movie on my television. Of course, the zoning law doesn't prohibit people in the RU district from doing that. And it's not a reasonable interpretation to argue that it does.
Thank you, counsel.
Thank you.
Counsel?
I'm glad it was brought up about the wedding, because I've always analogized this to having some sort of backyard party or wedding, or even, in my brief I mentioned, for instance, that what if he invited the town over for a 4th of July celebration and they decided to sing or play music? There's no, the statute really doesn't limit as to like the number of people or the length of time. It doesn't allow for the playing of music at a gathering for a shorter period of time than a longer period of time.
Well, isn't it sort of self-limiting? Because if you have to provide structures and you have to provide sanitary facilities and you have to provide food vendors or all these other things, isn't that what defines it? Because if you invite some people over for the 4th of July, that presumes they're going to stay for several hours or whatever, not for 3 days.
Okay.
And they're not going to be eating and, and all that stuff.
But that's not the objection that the law applies to. The law applies this particular statute or ordinance to the playing of music. And it doesn't distinguish between amplified
I
or
don't see where
non-amplified.
that is in the law, the playing of music.
The definition of theater is a building or room or outdoor facility for the playing, for the presentation of films, plays, dramatic performances, or music. It doesn't have any relevance to the amount of sound, how loud it is, or how soft the sound is, whether it's indoors or outdoors, whether it's daytime or nighttime.
It does say that nothing shall prohibit the uses allowed under the household
inside. The statute or the definition is that which is usually performed solely within a house. Well, I can make a lot of noise solely within my house. I could blast my stereo solely within my house and put the speakers near the window and disturb all my neighbors, and it wouldn't violate the zoning law, which is designed to prevent excessive noise. And the Constitution doesn't end.
Violate other laws, I mean.
It might, but there's no noise ordinance, which is what would have addressed the primary problem here, which was amplified music from dusk to dawn, could have been solved with a simple.
He said that they identified that there were other issues that concern them, given the size and the length of time.
But
that
that's
this
not
event
what
was
he
going on.
identifies as the purpose of the statute that's challenged. And under the narrow tailoring analysis, you have to identify, the government has the burden of both
Let's say we
identifying.
disagree. Let's say we agree with his description of what they've identified as their concerns raised by the event and what this zoning was meant to address. How does that affect your argument?
Because, first of all, the Constitution doesn't end when you leave the house. The Constitution, the First Amendment, applies to his entire 68 acres, not just those things you can do within a house. So these people have a right, freedom of association to get together. And they have, if they want 400 people want to get together in an open field on 68 acres, they have that right. They have the right to worship in that field. They have that right. But at the minute somebody plays a song or sings, then they have now created a theater which is prohibited by criminal statute. And that's where I think this law violates the First Amendment. There's no limitation in terms of, as I've said, daytime or nighttime, indoor or outdoor, or the amount of sound that's generated or not generated.
All right. Let's say we disagree with you. Is it your understanding, if you've looked, if you haven't, I certainly appreciate that there are alternatives with respect to the argument that there are alternatives?
Right. So that's where we got into on the respondent's brief and my reply brief, where Mr. Klein pointed out case law of this court that says, well, I have to prove that it's a violation beyond a reasonable doubt. And I cited the Second Circuit case law that says it's the government's burden of proof to demonstrate not only the nature of the significant governmental interest that the law is supposed to be narrowly tailored to achieve, but also the ample alternative channels. And the town did not meet that burden, did not demonstrate where within the town this could happen. How much of the town, what percentage of the town? Is it 1% of the town, 5% of the town, where these activities are allowed?
But it seems that
they
we don't,
failed their
it
burden of
seems as
proof
if we
on that.
don't know, because you didn't apply for a special use permit, whether and to what degree some or all of this activity would be allowed on Mr. Leifer's own land. And that makes it sort of difficult to reach the constitutional question.
I understand that. I don't, and I think, from my point of view, I don't think they would have granted. I mean, they told him when he was before the board, and it's quoted in the record, they told him that music festivals are not permitted. They considered this simply a music festival. They overlooked the religious observance aspect of this event, and they just told him it's not permitted. And that
Thank you,
is-
counsel.
Okay, thank you.